Yeah, good afternoon. I apologize for my colleagues who are late, but I think we should not waste time, and we are starting, and I hope that they will come in a moment. We continue with Article 12 of the Covenant, and the first question on the list of issues is Article 40, is question 45, where the State Report says that citizens of Taiwan are entitled to enter their country without a permit only if they have a residence registered in the Taiwan area. And the question was how many citizens applied for a permit during the last 5 years, and how often the permit was refused, and what are the reasons to refuse such a permit. Now, in the response of the government, we have again a confirmation, and also saying that there were 133,214 Taiwanese nationals without household registration who applied to enter Taiwan in the past 5 years. However, the National Immigration Agency does not have the count of the rejection cases. So whatever you could give us in addition, so in other words, Taiwanese citizens who were deprived of their right to enter their own country, we would be very happy to receive. And in general, Article 12.4 of the Covenant contains a more or less absolute right to enter your own country. So it says, no one shall be arbitrarily deprived of the right to enter his own country. The word arbitrarily there has a very, very specific, restricted meaning of the earlier practice in certain countries, like the Soviet Union, to exile people. So you first deprive them of their nationality in order then to being able to exile them. But for the rest, and that is confirmed by the jurisprudence of the Human Rights Committee, no citizen of any country should be denied entry. So I see a major problem here, that this condition that you have to apply if you are not registered in the country would violate Article 12.4. So I would be happy for any explanation, and perhaps also if the immigration authority could also give us some more figures, how many people have been actually denied to enter Taiwan. Who would like to respond?
On behalf of the Ministry of Interior, I would like to make some explanation based on the regulation regarding nationality in ROC. And currently, we use the parental lineage principle. That is to say, if one of the parents is an ROC citizen, then the children can be granted with the nationality. When we look at the history and the evolving history of ROC, we can see that there are there are a lot of people who do not have a residence registered. But of course, the laws and regulations have different stipulations for people who have residence registers and who do not have residence registered. But as long as one has ROC passports, he or she can freely enter or leave Taiwan unless there are special circumstances. For example, this citizen has joined a violent or terrorist organization or has participated in its activities or is strongly suspected to be involved in turmoil or foreign aggression, or the passport is obtained illegally. These are the only circumstances that prevent a Taiwanese ROC citizen from entering ROC. And indeed, the immigration agency does not have detailed statistics, but I think our delegate from immigration agency would like to respond. You can refer to the map. In the back, there is a map of Taiwan and a world map. You can see there are people who were born in Taiwan. 100% of them, if they leave Taiwan, they can freely come back. And there are two types of people who are citizens without residence registers. There are children who were born in foreign countries but to Taiwanese parents, or there are also children who are immigrants from Taiwan. So these are the people who do not have a residence registered. And the Grand Justice rules that since there are differences of these people's backgrounds and therefore there can be different treatments. But citizens without residence registered can freely enter Taiwan without visas. And we delegate the power to our representative offices in foreign countries to grant such permits.
Would you have also any statistics on how many Taiwanese citizens have been denied the right to enter the country in the last 5 years or in the last year, whatever is available?
Based on our Immigration Act, Taiwanese citizens can always come back to Taiwan without permit. So 100% of them can come back to Taiwan, and therefore there is 0 cases of deny.
In the paragraph 127 is said there were 133,000 Taiwanese nationals without household registration who applied to enter Taiwan in the past 5 years, but the National Immigration Agency does not have the count of the rejection cases. So there you say you don't know how many, now you say it's nobody. So are you saying that all the 133,000 Taiwanese nationals who applied were granted the right? Or have there been cases, for instance, on the basis that your colleague from the Ministry of Interior said, who joined a violent organization or who were suspected of being involved in foreign aggression or who were involved in major crimes, etc. These are reasons, I understand, in your law that would allow the National Immigration Agency to deny them access. Can you please clarify?
公委员在做说明的是，
all Taiwanese citizens can be allowed to enter Taiwan. And these, but these 130,000 people here are not Taiwanese citizens. These 133,000 people are not born in Taiwan, yet they have the ROC nationality. They just don't have the residence registered in Taiwan. That's why it requires an application for that. But for any Taiwanese citizens who have residence registered in Taiwan, they can freely enter Taiwan. And during martial law period, there was the blacklist. But after the martial law was lifted, there were no restrictions on the Taiwanese citizens in terms of prohibiting them from entering Taiwan.
You now seem to distinguish between Taiwanese nationals and Taiwanese citizens. You said yourself that, for instance, if two Taiwanese nationals or citizens who go abroad and they get children, these children, because of the jus sanguinis, I understand, are automatically Taiwanese nationals / citizens. In my opinion, that's the same, a national and a citizen. They have Taiwanese nationality, and therefore they have an absolute right to enter their own country, according to international law. But it seems that Taiwanese law contradicts this. They need, because they are not registered here, they need to apply for a permission to enter the country. Is this correct?
I think there's one point I have to clarify. We are talking about the ROC nationality. All ROC citizens or nationals and their children would have the ROC nationality. And I'm sure you are aware of the history of my country. So right now, the ruling territory of the ROC is now in Taiwan. But there are many ROC nationals who immigrated from mainland China to the third country, whose children still have the nationality of the ROC. So there are as many as 39 million ROC nationals who do not reside in Taiwan. But there are 23 million ROC nationals who have ROC nationality and reside in Taiwan. Therefore, we have more ROC nationals residing offshore or overseas. That's why we have these different rules applying to these two groups. This distinction or different treatment has been interpreted by the Grand Justices as they reflect the historical evolution of our country. That's why when we said, if you have the ROC nationality, but you live in a foreign country, you do not have a residence registered in Taiwan, so you have to apply for a permit before entering the country.
understand, of course, the particular situation, but still the covenant speaks to enter their own country. Would you consider Taiwan being the own country of the 39 million ROC nationals who do not reside in Taiwan? Can they legitimately consider, say, Taiwan is my own country? Or not?
Yes, we do recognize them as our nationals. So even though they have to apply for a permit, as long as they don't have any of the prohibitive conditions as listed in the reply, they can enter the country after they get the permit. As for the statistics you asked about, the number of rejection cases. There were 3 rejection cases. Most of the rest are approved.
$5 years, or this year, in the last 5 years. All right.
5年內
During the past 5 years. The past 5 years.
For this clarification, and we will consider it again when we draft the concluding observations, to what extent this is in line with Article 12 of the Covenant. Now I come to the other way around. According to your state report, more than 50,000 citizens of the ROC were prevented from leaving their own country in 2011. And many of these restrictions were issued by administrative authorities, tax authorities, and similar one. Can these decisions be appealed to the courts? Does the appeal have suspended effect? And also, what are the protection cases? We did receive an answer, but I think, in my opinion, in particular also the question of access to the court has not been dealt with in a satisfactory way, because about half of the people who were prohibited to leave Taiwan were made these decisions at the request of administrative agencies. But can you say how quick do they have access to a court review of these decisions, not to be prevented to leave the country?
I'll speak on behalf of the immigration agency first. There are 2 issues here. The exit restrictions are imposed upon those who have violated existing laws. So these decisions are made by prosecutors and judges. And another group face these restrictions because the decision was made by the tax authorities. In that case, they can petition for administrative intervention. In the event of emergency, the party may petition to the administrative court. Or in some cases, if this person has been found guilty of a crime and this person received a parole after serving time in the prison for some period of time, then this person may be turned as protection cases who can go abroad if the prosecutors agreed. Come from the protection agency. These protection cases would need to receive approval from the parole officers before they want to leave the country longer than 10 years. However, if they have objections to the prosecutor's decision, then they do have a chance to raise their objections through the judicial system.
Cases, so if persons have been sentenced by a court and released on parole, that there is a protective measure that they are prevented from leaving the country, and quite a high number of these cases fall into this particular category. But in relation to tax, the tax administrative authorities, we are not talking about persons who have been sentenced by a court. Can you give us more information about the number of persons who have been prevented, again Taiwanese citizens, who have been prevented from going abroad only because they might be in delay in paying their taxes, without having now committed a criminal offense, but only for tax reasons? And I'm asking this question because in general, a number of 50,000 citizens prohibited to leave their own country in 1 year, again, if in comparison with other countries, is extremely high. Of course, Article 12.2 says everyone shall be free to leave any country, including his own. So in principle, you have a right to leave your own country, but Article 12.3 provides for certain restrictions. So, and that we have in all countries in the world, certain restrictions for reasons of national security or public order, etc. But as I said, 50,000 is a very, very high figure, and I would like to know how many of these are related to tax authorities' decisions.
I speak for the Ministry of Finance. On the issue you just raised, according to Article 24 of Tax Collection Act and the Customs Tax Act, if a citizen fails to pay the tax amounting to a specific amount, then first of all, we would try to secure this person's property. We would restrict this person from transferring his property to other persons or setting trust on his property. If we detect some signs that this person is going to get rid of his property in order to avoid paying the tax, then we would have a preliminary injunction on this person's right to handle or process his property. So it does not mean that as long as the person fails to pay his tax or delays in paying his tax, he will face such exit restrictions. It is only when the amount is so large, reaching a particular threshold, then such restrictions will be imposed. Moreover, we would also provide this person written information about what remedies he may seek after he received the order, so he can petition to the court according to the Administrative Appeal Act, asking to revoke this particular restriction. According to the Tax Collection Act, the exit restriction cannot last longer than 5 years. So far, the number of cases that fall into category totaled about 8,806.
To be sure, 8,806 cases in which period, or presently, or 2011?
As of now, as of the end of February, 8,866 cases face exit restrictions. Maybe the Ministry of Finance can explain further, because on page 42 of the state's report, it said about 18,084 cases fall into this category in 2011. Well, I don't think the 18,000 cases in 2011 were all related to tax collection. Failure to pay taxes, cases involving failure to pay taxes totaled 15,012 so far. This is the data we gathered this morning. Maybe after the meeting, I'll ask my colleague to reconfirm. We have to gather the statistics from different units and departments, so we will have to compile them before the end of the conference. We will we will get back to you. Maybe the Ministry of Finance can ask your colleague back in office to do this. Let's get back to the reviewers by the end of the meeting.
This information also because according to the table 22, there is a gradual reduction of the numbers of exit restrictions for nationals. So in 2007, the total number was still more than 100,000 people, and it went down to 51. And most of this is due to the financial and taxation control. So in 2007, there were more than 55,000 persons who had exit restrictions only for financial and taxation control reasons, and that was going down to 18,000 in 2011. And if I add the number you mentioned now, 8,800 66 citizens today, then it would be a further reduction. But as I said, I would be happy for every additional information you can provide. And also, I'm not quite clear how, if the tax authority decides that a particular citizen is not allowed to leave the country for up to 5 years, how quick can you get a court review? And if you have any statistics on these cases, I would be particularly grateful. So how big is the chance that courts would actually then quash the administrative decision for exit restrictions? I don't know, would you like to respond now or later?
因为我们目
Currently, if taxpayers are not satisfied with this limited access, then they have to apply for remedy based on Administrative Appeal Act or Administrative Appeal Act. They will need to follow those acts to apply for remedies. And our Administrative Appeal Act, it stipulates that within 30 days after this person has received the order of this disposition, he or she can submit the petition. Within 30 days, he or she can submit the petition. I am from the Administrative Appeal Office. Speaking of these cases and the statistics, I don't have it right now, but I'm asking my delegates in my offices to collect information right now, and I will return it to you later.
Do we have any further questions on this? Then I come to question 47, which is as sensitive, I would say, and that refers to the, I would say, highly restrictive policy relating to HIV-positive aliens and mandatory HIV testing. And if persons testing HIV positive, then they are required to leave the country or are forcibly deported, even applying to foreign spouses of Taiwanese nationals. Again, we received a short answer that is confirming this information, and we received quite a number of very, very serious criticism by the NGO community. And I should actually add that if you follow the World Health Organization's policies on HIV/AIDS and UN AIDS in relation to mandatory testing and all kind of restrictions following from testing HIV positive, that in my opinion this is a policy that seems to be somewhat outdated, because in the meantime there are all kind of ways of medical treatment, and the original reactions of some countries to expel all foreign citizens who are HIV positive have been changed in many countries because of appeals by UNAIDS, WHO, and also United Nations human rights bodies. So my question is to what extent the government of Taiwan is willing to reconsider its highly restrictive policy in relation to HIV/AIDS.
OK， 好，我是卫生署的代表哈。那现在卫生署
I'm from Department of Health. Now, in the case of the HIV positive alien, indeed, the current regulations allow the revocation of their visas and deport them. However, if they are infected because of their ROC nationals, or because they are infected because of the medical treatment in Taiwan, or they have their second-degree relatives who live in Taiwan, then we are considering to eliminate such restrictive procedures on aliens, on HIV-positive aliens. And the change of the regulations are being changed right now. We plan to submit the revision to the Legislative Yuan at the end of this year to remove these procedures in the old law. And you mentioned recommendations from WHO. I think in terms of some of our procedures, what we did are even more advanced. It is just that our policies for aliens are not that advanced yet. But for HIV-positive aliens, for HIV-positive people, we provide free treatment, and we have more than 400 free screening stations. We also and the screening services are anonymous. And if people are infected because of blood transfusion, we provide remedies or compensation to these people. Then on the front of education, we continue to use education to educate people in Taiwan. We also establish shelters for HIV-positive people, because currently, indeed, some people in Taiwan are not very accepting of people who have HIV, and we want to use these shelters to help HIV carriers to have a regular life. We have support organizations too, so that people who have HIV can support each other and form a supportive network. And their right to medical services, to education, their right to privacy are all stipulated in laws and regulations. And on a daily basis, we monitor the news on the media, and we monitor whether the media infringes upon any rights of HIV carriers. And we have a 24/7 complaint hotline, which has the number 1922. So at any time, if an HIV carrier wants to submit complaints, they can use this hotline. We also have a committee on this regard, and they meet once 6 months. And there are 4 subgroups under this committee. These subgroups meet once every 2 months to review our current procedures for HIV-positive people, and we are trying to catch up with the international trend in this regard. I'm from Immigration Agency. We cooperate with the Department of Health at all fronts. Before the law was changed, we tell HIV carriers as to how they can submit complaints, how they can apply for remedies. So we do provide such education to HIV carriers.
Thank you very much, and I hope that in due course the relevant legal provisions will actually be brought in line with international human rights standards. 48 is the question, when does the government of Taiwan intend to enact an asylum law? In paragraph 134 of the reply of the government, it says the draft of the Refugee Act was established and released in 2003, and the Executive Yuan delivered the latest draft on 23rd February 2013. I received a draft of the Refugee Act by the National Immigration Agency dated 21 September 2011. Is this the latest draft? The second question is, what are your... Sorry?
Yes. 所以这个
What are your expectations when it will be adopted?
这个部分哈。
Well, the Refugee Act was also discussed in this morning. The Refugee Act and the revision for the Cross-Strait Act will be submitted to the they have been submitted to the Legislative Yuan already. So the Legislative Yuan will decide the timeline on reviewing the two acts. May I also add something? The authority to revise laws is in the hands of the Legislative Yuan. And the Premier Zhang has instructed us to have better communication with the legislators to help them understand the importance of effective review and passage of this act. But we do not have a very clear timeline on the process at this point.
I also received a joint statement calling on the Legislative Yuan to pass the Refugee Act by quite a number of Taiwanese and international non-governmental organizations, where there are very detailed comments on the draft, which I hope will be taken into account. And in that respect, and I am going now to question 49, the issue was raised whether the principle of non-refoulement is taken into account. And I have read Article 8 of the draft law, which is containing a principle of non-refoulement, but only insofar as it is provided for in Article 33 of the Geneva Refugee Convention. As the committee that is reviewing compliance with the International Covenant on Civil and Political Rights, we have, however, to remind you of the fact that the Human Rights Committee, as other bodies have done, has developed a general principle of non-refoulement on the basis of Article 7 of the Covenant on Civil and Political Rights. In other words, that whoever, whether this is a refugee or another alien, is at a serious risk of torture upon being returned, extradited, expelled to another country, should not be returned. And that is an absolute prohibition of refoulement, which applies irrespective of whether or not this person is a very dangerous person, has committed major crimes, political crimes, non-political crimes. It applies to everybody and absolutely. So Article 8 is not complying with the requirements of the Covenant. It only complies with the requirements of the Refugee Convention. So my question to you would be, can this still be taken into account when the Refugee Act will be finally adopted? Because otherwise we have a major problem in relation to the non-refoulement principle.
Thank you very much for your advice, and we will explain your points at the Legislative Yuan. Thank you very much.
Anything my colleagues would like to add? Please, please.
不好意思，我现在。
I have some statistics that I would like to report to you. We talk about the number of cases facing exit restrictions because of financial or tax problems. I told you 886. But in table 22, you saw the number 18,000. Basically, this is because a person may have 1 or 2 records of failing to pay taxes. That's why there's the gap between the two numbers. So far, in terms of the number of cases, it's 15,012, but in terms of persons, it's 18,886 persons.
Do understand? I think your colleague from the Ministry of Finance would like to add something.
Yes, I got the data from my colleagues in the office. Those who face exit restrictions because of tax issues numbered in 8,800. So the same person may be involved in 2 or 3 cases. That's why you will see the gap between these two numbers.
I still hope that we receive also the more recent information in writing. That concludes the discussion on Articles 12 and 13. Since we have dealt with 14 already, and there were no questions from us in relation to 15 and 16, so if there is nothing else from my colleagues, then I would move on to the right to privacy and family life, and I would like to give the floor in this respect to my colleague Shanthi Dairiam. Oh no, it was first Asma Jahangir, yeah. So that starts with the issues, list of issues 59. You have the floor.
I think let's just come first to page 82 of your response. This is Article 17. I have very direct questions, and I would like to say, first of all, that this is your initiative. We are here to assist you, and this is something that you are taking the lead in. So our dialogue here and our discussion here is to to your benefit and to the mutual benefit of human rights. And I think it's in this spirit that all of us are here, in trying to engage each other, the realities and the aspirations, to put them together. On page 82, in paragraph 2, just at the end of the page, you have said that non-governmental agency, unless proven to be unintentional or negligent, should be held liable if it fails to abide by the provisions of the stipulated in the law and leads to illegal collection, processing and utilization of personal information or other infringement of the rights of an individual. Now, my understanding is that a number of non-governmental organizations, particularly those working in the human rights field, would be taking up individual cases and reporting on these, particularly where violations have taken place. Naturally, they will not say that so-and-so is guilty, but they will say that it is reported, or that our information is that so-and-so has committed this crime. Now, would that fall under the criminal code articles that you have given above in paragraph 189 as a question of deprivation of freedom of privacy?
Who would like to? Minister of Interior, please.
我想因为这个隐私权的保护涉及
In terms of the protection of privacy, many government agencies are pertinent agencies. So I would like to provide a general explanation. In Taiwan, we have a Personal Data Protection Act. So in our existing laws, if government agencies in possession of this personal data use this data illegally, then the person who owns the data can file for compensation as much as 200 million new Taiwan dollars. For non-governmental agencies, if the same event occurs, the party related can apply for compensation, and the person can ask for his reputation to be reinstated if his reputation is jeopardized. So these are the provisions in the Personal Data Protection Act. Moreover, according to the Criminal Code, Article 351 stipulates that if you get hold of other people's privacy or secrets via illegal means, then it is an offense. In the Code of Criminal Procedures, in the investigation stage, prosecutors, judges, or police officers, or defense attorneys shall not reveal the secrets, the privacy of the parties concerned. I think you are also concerned that during the crime investigation stage, we have this communication surveillance operations. We have related laws in place. The MOJ and the police administration have decided on specific rules as to how investigators or police officers should perform these investigative duties. So I think I'll pause here. Later, if the MOJ and the Judicial Yuan can provide additional information.
make that clear. These are two different things. The surveillance under the Communication Protection and Monitoring Act is different. And I'm not discussing that at the moment. I am discussing the provisions of the Criminal Code, where it is said that non-governmental organizations, unless they prove that what they have disclosed is unintentional or is not negligent, they shall be held liable for criminal liability. I know that under the Personal Information Protection Act, it is compensation. It's a civil suit. But here I'm talking about criminal liability of non-governmental organizations who are putting out information, and as a case happened where a non-governmental organization who has put out information has been challenged in court or has been prosecuted by you.
Okay, I'll speak on behalf of the MOJ can respond. Thank you for the question. If the NGO, non-governmental organizations, leak personal data or private information, we said if there is legitimate reasons for doing so, then no criminal prosecution may be imposed. When prosecutors work on a criminal case, the prosecutor has to make a case showing that you have intentionally leaked the information to someone else. The prosecutor has to establish this fact. And of course, you also have to take into consideration whether this act is reasonable. So very often the defendant would say, I do have legitimate reasons for doing so. So it does not mean that all NGOs would be challenged in court because of leaking information. Basically, Taiwan pays close attention to protecting privacy, personal privacy. That's why we have this Personal Information Protection Act, PIPA, starting 2012. And there are two main sections, one governing the government sector, the other the private sector. We know that in the multicultural society, we do want to encourage the dissemination, free dissemination of information. However, we also have restrictions on the collection and utilization of these data. Legitimate reasons must be proffered first. So personal data, including the person's names, fingerprints, etc., are protected. And we also have the Communication Surveillance Act, which is another example of protecting privacy. And we also want to promote transparency in government. So the information held by government should be made as available and accessible to the public as possible. So we do have two systems at work at the same time.
The Freedom of Government Information Law, you have the Personal Information Protection Act, but there has to be a balance between the two. Because you cannot, in the garb of protection, personal protection, hide from people vital information. But at the same time, under the Freedom of Government Information Law, you cannot hide information that is vital for people's public importance. So that is why I am going to be very specific. And the Communication Surveillance Act is completely different, which I'll come to later. Have there been any cases of prosecution of non-governmental organization under this specific criminal code? Specific provision of the criminal code. or under the Freedom of Government Information Law?
In response to your questions, according to the criminal code, well, let me give you a few examples. Some cases we investigated showed that the companies, without a legitimate reason, tapped into the general public's privacy. So the key is the absence of legitimate reason. And there are cases where the wiring or tapping facilities were installed into the private house. That is, of course, a violation. But I'm talking about private enterprises. As far as I know, there is no prosecution of NGOs on that ground.
Also have on page 83 a list of the Communication Protection and Surveillance Act, and you have given the figures in paragraph 203, where 17,458 people were being under surveillance in 2012, and 1,034 in 2011, and in 2012, 41,599. So my question is, what kind of cases are these? Are these cases of crime where somebody has committed a crime and has run away? Are these cases of detecting white-collar corruption? Are these cases where people could say that this is politicized surveillance of people who belong to the other side of the political spectrum? And thirdly, what I would like to say is that you also say that there is no illegal practice found in all these, that in all these 41,599 cases, that there was no illegal practice found. But were there any complaints made against these surveillances? What is the evidentiary value of these surveillances in a court of law? These are the questions that I really want to put on this act particularly. Have you got it?
I would like to respond to that. Well, under the current law and regulations, the surveillance, we have the Surveillance Act, and the three elements must be satisfied if it is to make it a legitimate cause. The first element is that there are no other ways to monitor, and the second element is for serious crimes. So 60 to 70% of these kind of cases are drug cases or gangster cases, organized crime. And the third element is this case is related to criminal offense. So you mentioned politicized case. No, because it's not one of our, it's not among our three elements. So the first element is that there are no other ways to investigate, and the second element is that it is for serious crime, and the third element is that the case is related to criminal offense. These are the three elements to grant the permits of using such technique.
surveillance, you are looking at what they are saying, you're collecting information, and when you go to the court of law, what is the value of that evidence that you collect during that surveillance?
In the Surveillance Act, it states that judicial police officers have to make the application, and the application is reviewed by the prosecutors, and then the prosecutors submit the application to the courts. So the process is a judicial process. It is under judicial review and control. If the practice violates this act, then the evidence derived in this process is not admissible in the case, because that evidence will not be qualified as admissible evidence. The prosecutors may apply for the writ of surveillance, and the courts have to approve the application before the wiretapping can be installed. If the writ is ordered and the evidence is collected under this writ of surveillance, then the evidence will be admissible.
No illegal practice found, that every time the procedure was followed. I mean, I take it from there that every time the prosecutor asked and the prosecutor went to court and got the writ and did not do anything on their own, because you say no illegal practice was found in this area. And also you say that people did object to the surveillance practice. Now, how many cases would there be in court where there would be individuals out of the numbers that we have here? Just a rough idea, I don't want exact numbers. Like if there are 41,000 people, would there be substantial amount of cases where people would go and say, look, this is wrong, my telephone is being tapped, it is being tapped for no reason? And have there been any rulings by the courts saying, well, this was done legitimately or illegitimately, and that they have put down certain guidelines further refining how the prosecutor may ask for permission and when the prosecutor may not ask for permission or may not be allowed to do it by the court?
在这个情形之下的话呢，检察官或者包括受到警察透过检察官，或者检察官直接向法院来申请，法官在审查的时候呢，要看相关的事证，他可能不是绝对的证明好，没有听到。
It may not be. The prosecutors have to submit evidence and submit that application to the judges in order to apply for the writ. And the judges will review these evidence and acts. Maybe this evidence is not 100% sufficient. Yeah, the evidence can show that whether this is a case of kidnap or a drug case. So the judges will review these facts. So it's not that the judges approve such an application every time. And if police officers violate the act, then they're subject to imprisonment no more than 5 years. So illegal wiretapping is absolutely prohibited by law. Of course, some people may say, "Oh, I'm wiretapped." But since we have the writ system, there has to be the writ before wiretapping can be installed, and people who do not have the writ and they go ahead and install the wiretapping will be subject to punishments, criminal punishment.
One additional question here. At which point does the person who is put under surveillance informed? Is there an obligation? So for instance, if you have telephone tapping for, I don't know, drug-related crimes, and then you're stopping the surveillance, are you then under an obligation to inform the person that he or she has been subjected to surveillance? And if so, then, because that's then the point when the person only knows, usually you are not aware if your telephone is tapped. You might get aware, you might have, but many people don't get aware. Do you then afterwards have still a remedy, saying, but this was illegal for the various reasons, and do you get reparation if you use this remedy? Because I understand the statistics in 202, those are only cases where first the prosecutor and then the court turned down a request by the police before the surveillance measure actually had been put in place. So my question is there afterwards a remedy for the person concerned?
What we are trying to ask is that we understand that there were so many applications, you put in so many petitions, not every petition was agreed to. The court gave you permission legitimately for surveillance of a number of people, and all these figures are given in 202 and 203. However, in 201, you say there is no statistics concerning the petition initiated by the judicial police, and no information concerning the complaints. That's also fine. But what we are trying to ask is that there happens in cases where a person inadvertently gets to know that my phone is being tapped and goes to court and says, why is my telephone being tapped? This is incorrect. That is one situation that could occur. And the other situation is when the case comes to trial, and then they find out from the evidence being presented there that you were under surveillance. And then the person challenges the law, saying, why was I under surveillance? Because I have been completely innocent. So have there been cases there where people, because there are a large number of people under surveillance here, that's the reason we are asking, have somebody sort of challenged the illegality or the legality of the act of surveillance, regardless of the process that may have been followed, which may have been the correct process?
And of course the third category is if you have a policy of informing the persons as soon as the surveillance measure has been terminated, which is the case in many countries in the world, that you need to inform them in order to provide them a remedy. So my question is also, is such a policy in Taiwan, and have there been these cases?
In the view of the ministries or agencies or departments concerned on this from the government of Taiwan, how useful has it been to spend so much resources, effort and time on conducting a surveillance on so many people? I was quite amazed at the number that you have, the statistics you have given, like 35,000 people under surveillance. How useful has it been necessary, and how useful has it been for you? Maybe you could, have you assessed this? I'd like to know that as well. Isn't your time spent in better ways? That is what I'm asking.
And money.
But these numbers are nothing compared to the numbers in my country.
We won't compare with Pakistan.
那针对委员所提出的有关这个监听结束之后会通知这个被监听。
On the question whether we inform the person who is put on surveillance, well, now based on the Surveillance Act, it stipulates that after the surveillance, then the name and the residence of this person has to be submitted to the prosecutor, and the prosecutor submit this information to the courts. After the approval, then the result of the surveillance will be informed. Well, the person who is wiretapped will be informed of the result of the surveillance. And there are exceptions. If this person is still involved with other investigations, then the notification can be suspended. But generally speaking, the person who is wiretapped will have to be notified after the surveillance ends.
Asked, have there been cases where people have said that they have unfairly been put under surveillance and that they want remedy for it or challenge the surveillance? That's all we are asking. Have there been cases of this nature or not at all?
And have anybody been successful in challenging it?
In response to your question, in my own experience, none. I will ask my colleagues back in the office to check out whether there are such cases where people challenged this legality of the surveillance. In fact, these people can express their objection to the surveillance measure according to the Code of Criminal Procedures. You asked about cases where people challenge the legality of the surveillance measures. Again, I have to go back to the office to find out the answer. In the case of illegal surveillance, the person can ask for a daily compensation of 1,500 to 5,000 New Taiwan dollar. However, so far, I don't recall such cases, but that's the amount of reparation or compensation the rule says.
Question of the media, I have basically two questions, and I think we've asked those earlier as well, but we haven't got very comprehensive responses. The first is that you say, and that is correct, that you don't have any anti-monopoly law governing the media. Now, where is it? Is it in the pipeline? Is it coming? And the acquisition and merger that is between the What and the other two agencies that is on the cards. Is that going to be stopped, or is it going to happen before this comes in? Because basically that is what has prompted many people from civil society into demonstrating for breaking up the monopoly in the media. And this is a very serious issue, because if the media is monopolized by vested interests, then you have a huge problem with having a healthy democracy going forward. So where is this law in the first place? And even when this law is not coming into being, has any action been taken so that immediate merger that is on the card, which has prompted protests and outrage, public outrage, that is being taken care of?
In response to your questions, in February, we have completed a draft on the anti-media monopoly law. it is expected that in June this year, we are going to present this draft to the Legislative Yuan. As for the content of this draft, print and electronic media will be subject to the provisions of this law. So any mergers and acquisitions involving electronic and print media will be subject to the purview of the law. In the case of such mergers, we will review according to these provisions. And of course, before the law is passed, the draft is passed and enacted, when it comes to the mergers of print media, the Fair Trade Commission is in charge of reviewing these mergers. For mergers involving electronic media, the NCC is in charge of reviewing the mergers.
Read it correctly, that despite the fact that the law has may not come into being, both the Fair Trade Commission and the Communication Commission will in any case have the authority to stop or to give permission to any mergers presently taking place.
I speak on behalf of the Fair Trade Commission. Thank you for raising this issue. First of all, so far, we have not found any monopoly of media. In terms of the electronic media, during the past 4 years, we reviewed 4 cases involving MSO mergers. And in each case, the operator's market share was less than 30%. And the NCC has very stringent requirements. The operator's market share shall not be over 30% if they want to apply for mergers. So during the past few years, we reviewed 2 cases. And at the NCC, there are also similar cases, but none of them resulted in monopoly of media. In Taiwan right now, we have many different channels run by radio operators. And in the cable TV operators, there are also many different operators and channels. So it's very difficult for one operator to monopolize the market. Moreover, ever since the lift of the ban on print press, so anyone can now publish a newspaper. There are no legal restrictions whatsoever. That's why we have over 2,000 registered newspapers in circulation. Of course, some have huge volume in circulation. Some are tailored to small groups of people. So there are no entry barriers to the newspaper market. As for the other types of print media, again, no restrictions for publishing magazines. As for the anti-monopoly law, as proposed by the NCC, I think in the future we are going to see more cases where the print media gets expanded into the electronic media. So right now, under existing laws, there's no way a media operator can monopolize the whole market.
Some of the information that we got from the NGOs was Taiwan's Want China Times group, so that the Wang group boss a lot of profit in China to become the richest man in Taiwan. In 2008, he suddenly returned to Taiwan, acquisition media in Taiwan has 3 free television channels, 3 cable TV. Now he is acquiring of the country's second largest cable TV system platform, as well as the top 2 of the national circulation newspaper, 1 of Apple Daily. So, I mean, these are the kind of, not just this one, but we got several of these information and concerns that the NGOs have shown. Now, these could be genuine or these could be just speculative concerns. We do not know. But I think it will be good to hear from you, from the government side, that these concerns are indeed unfounded.
谢谢委员的提问。首先，我必须要
Thank you. Just we are in regular contact with these civil groups, so we are aware of their concerns. Yes, anti-monopoly is a universal value. Freedom of speech and the right to free expression are also rights the government would like to safeguard, just like the civil society. So the anti-monopoly in media draft is right now under review. As for the 1-1 case, there are 4 potential buyers of the next group. There's one particular Mr. Tsai, who is also the owner of the China Times Group. So among the 4 potential buyers, 3 of them do not own any media business. Therefore, when we review these cases, we consider them to be building a diversified business in their conglomerate. And for Mr. Tsai, this is a case of horizontal merger. At the end of last week, we just notified these potential buyers to provide supplemental information. In particular, Mr. Tsai, owner of the China Times Group, has to provide more information on his ownership in the China Times. And we also ask these buyers what their business strategies are if they acquired the next group. Do they plan to impose any specific restrictions on the transfer of ownership in this media? We asked for very clear explanation about their future strategies. And in this merger, actually, there were 2 different contracts being negotiated. And the first time we reviewed the case, we actually asked the parties concerned to explain to us the relationship between the 2 potential transactions and why there are 2 buyers in these mergers overlapping. Right now, we have not received their applications formally. The rest is just media reports.
No. How are the members of the Fair Trade Commission appointed? Who appoints them? What is the background? And also the Public Television Service Foundation, where some directors are appointed, but 2 are left, I believe. And when will that process be completed? Because there the government says that they want to diversify the directors of the Public Television Service Foundation. But who is appointing them and what are the backgrounds? Just, is the media people also themselves, journalists themselves, part of this process or not?
首先我必须要跟委员报。
First of all, in terms of the public television, the Ministry of Culture is in charge of that matter, so they will get back to you. As for the FTC composition, there are 7 members, including the chairperson and vice chairperson. All decisions on the commission will be made based on majority decisions. The premier will nominate the the commission members and the legislative yuan will have to approve. At least 50% of the legislators would have to agree before these people can become the members on the commission. Moreover, people from the same political party shall not account for more than 50% of the commission. In addition, these commission members should come from different special backgrounds. So 7 members of the commission, and they will be staggered term.
I'm from Department of Culture. Now, when it comes to the selection and the election of the board members for public TV stations, well, the 4th term was ended in December 2012, and that was when the process of selecting new board members started. In the past 2 years, there have been 5 meetings, and public TV station law stipulates that 3/4 of the reviewer members have to approve the assignment before this person can become a board member. This is a really high threshold. So in the past 2 years, this threshold has not been met, and so far we have 13 board members and 3 supervisors. So we are in shortage of 4 more board members for the public TV station. We're still working on finding enough board members for the public TV station.
And I think the membership that you have of the board is really quite impressive in the way they are selected. I would just now like to just go on to speech as well, where you have given certain offenses, freedom of speech, but the derogations to freedom of speech. And I would like to know whether sometimes these laws are made, but they're never really used because they've been made many years ago and people just forget about them. But certainly, some of them are not in conformity with the ICCPR. For example, defamation of religious buildings and ideological locations. Now, does that mean that if somebody says that I don't like this church, it's very ugly, would that be defamation of a religious building? Or that I don't agree with this religion, I think it's a very harsh religion, that would be defamation of religion. And why I ask this question is that when I was rapporteur for 6 years on freedom of religion or belief in the UN, this is a constant debate whether defamation of religion is a human rights violation or not. And clearly, the consensus was that it is not a human rights violation. In fact, to a point, it is a freedom of speech question. But if it is speech that incites hatred, discrimination, incitement to violence, then that would be not defamation, but that could come under a derogation for freedom of speech. Secondly is disseminates rumor or spread false saying. Now this is very vague kind of a restriction on freedom of speech. And then there is forbidden instigation or contracting for a lawsuit, which I don't understand. But there are many laws in my own country that I don't understand because they were made years ago. And they remain there on the statute books and nobody ever invokes them. So my question is, are they being invoked? If they are not being invoked, should you not be looking at them now that you are implementing the 2 covenants and taking these away? Because these give a very false impression, as though you're a religiously intolerant society, which you are not. Of course, we all know that. Because people have a right to criticize religion. People have a right to have debate on religion. And you cannot asphyxiate debate in any event on religious ideology or on the shape of a religious place like a mosque or a temple or, a church or whatever. So this is my question to you on Article 19, on this prohibitions that you have given in your criminal code.
Who would like to to respond?
针对委员所提问的，那简单说明如下。
Okay, our current constitution stipulates that people have right, freedom of speech, but Article 23 also stipulates that in the name of protect public interest or public order, the law can impose some restrictions on freedom of speech. And as to whether the Article 246 has ever been invoked, I think I can submit more information later. As far as my recollections go, this provision, Article 246 has not been invoked, but can I get back to you later? So this is a brief response to your question. Now, the crimes here are crime offenses that may be related to freedom of speech, but they do not necessarily always have connections with freedom of speech. But we know that there's the protection of freedom of speech in ICCPR. So now we have a review panel that reviewed criminal code. So we are reviewing the criminal code article by article, and in these within 2 years, we will review, especially on the element of the protection of freedom of speech in our criminal code based on the ICCPR. Well, Article 157 means obstruction to justice in European countries or other countries. They are similar. They are not exactly the same crimes, but they are similar on some aspect.
Is that also just there and never used?
I'm from Ministry of Interior. This is in the Election Act for public officers. So the rumor offense also needs some elements to be satisfied. That is to say, if a person intentionally spreads some rumors at the aim of having another person not being elected, will this provision be applied and invoked?
On defamation of religions, on the question of freedom of religion, particularly on the question of how do you register a religion, do you have specification of what forms a religion, how will you register it? That's my first question. Does it say it has to be so many people in a religious group? How does the state recognize it? But if the state doesn't want to recognize, and if it's not the matter of the state to recognize religions, that also I would like to know, because in your replies and in the reports I've got, it doesn't say anything about it. Supposing there is a religious group that doesn't register itself, but still continues to meet and worship together, is there any law forbidding that, or is that acceptable? Does every religious group have to register themselves? Yes or no? If yes, then what are the specifications? If they do not register, and they continue their worships and their rites and their traditions. Is there any breaking of the law on that account?
ROC supports freedom of religion, so all the religions can exist at ROC as long as it does not interfere with public order or hurt anyone else. As to registration, in fact, if a person wants to create a new religion, then he or she will come to the Ministry of Interior to register. And if a person wants to create an individual religion, such as Buddhism or Christianity, then they need, the elements are that they have to have their own rituals and ceremonies and their classics books, so that they can be recognized as a new religion. So if I want to create a new religion, then, and I want to be recognized as a new religion, I have to prove that we have our own rituals, ceremonies, and rules. As long, as to the number of the members of the religion, we do not monitor that. The religious groups can themselves recognize the members of the group. We have a religion review committee, committee, and the members and different people from different religions are assigned by their own religions to be on this consultative review panel. And if there's a new religion, then this review panel will invite this person to come to the panel, and for this person to explain the new religion I want to create is very much like Buddhism, but there are some differences, and the differences are so and so. So this person has to come to the panel to answer and explain. And under the same religion, there can be several religious groups. So we have a People's Group Act. It can be a local people's group or a national people's group to register. After the registration, after being approved, then this group will be a group that has registration with the government. But there are some groups who do not want to register with the government. For example, a person wants to practice this religion at his or her own home. They want to worship in private. As long as this practice does not interfere with public order, it's totally allowed.
The question of taxation, because I know that there is the Thai Jai Min group, which was taxed despite the fact that they say that they are a religious group and of belief and religion, and that they have won their case throughout till the Supreme Court, and yet the taxation, sort of order stays there. And moreover, the leader of the group is not allowed to leave the country, which again is not because of any other reason, but because there is a dispute saying that the taxation he has to give is not because he's personally earned that money, but that it is a charity given to that group. So I want to know the background of that, because this case is obviously one of the top cases on religious freedom here.
这个部分的话，我想太极门啊，太极门。
Okay, Tai Chi Men has introduced themselves on their website as a Qigong and martial art organization. So people gather to practice Qigong or martial arts. It is explained so on their own website. It doesn't say it's a religious group on its website. And and the Ministry of Interior's information, we have not received registration from this group. So the taxation issue right here, I think I need to move this question to our my colleague at the Ministry of Finance to answer. Okay, before I explore this case, I want to give you some numbers. So people who are people who cannot leave Taiwan because of taxation cases, I want to give you some numbers. From 2008 to 2012, there were 61 cases where the people were limited to leave Taiwan, and in 8 cases, people won, and 53 of the cases, or the petition cases, were denied. So these are the numbers. As for the taxation case, maybe allow me to ask my colleague to answer.
Good afternoon. In relation to Taijimen, this morning in the next room, I already explained to the committee members. Mr. Hong Shihe and his wife founded Taijimen and taught Qigong to their followers. In that case, there are 2 issues. First of all, Taijimen sold backpacks, cushions, and outfits for practicing Qigong to their followers. And these apparels actually resulted in business profits. Moreover, those followers learned to practice Qigong. These followers please allow me to refer to the documents. These followers each paid 20 to 30 or even 50,000 new Taiwan dollars to the masters. And they offered many courses around Taiwan. So the tuition income totaled more than 100 million new Taiwan dollars. That's why we believed that the couple should file taxes. Miss You Meirong, that is Mrs. Hong, did not file the taxes properly for 5 consecutive years. So the litigation went on. The decision in the end said that Taijimen claimed that they have been found non-guilty in the criminal case. Yet the administrative litigation is still pending. However, they obviously violated the law because they evaded taxation. And the decision basically said that Mr. Hong and Mrs. Hong did not intentionally fail to pay the taxes, did not intentionally engage in fraudulent activities. They simply failed to pay the taxes. That's why criminally they were not found to be guilty. However, when it comes to taxation, they should pay income tax as well as business tax. In the same decision, it is said that the followers paid the masters 50,000 New Taiwan dollars as tuition fees to learn Qigong. In other words, Taiji men had income. Then income tax should be paid to government. There was the revocation of the administrative action. However, this revocation was made on the ground that the calculation of the amount was not precise and accurate. It does not mean that Mr. Hong and Mrs. Hong did not need to pay taxes. So all these relevant issues are addressed very clearly in the final decisions. Moreover, in the decision, it is said that the petition committee members were not the same members on the tax collection committee. Moreover, in the taxable period, the court basically, the taxable period still applies. So the couple still needed to pay taxes. As for the exit restriction, as you mentioned, that can people be restricted from travel because of tax problems? Well, the immigration office, the immigration agency would like to provide supplemental information. In 2006, Mr. Hong left Taiwan. He is still in a foreign country, not in Taiwan right now.
Can he come back to Taiwan? Is the question.
刚才的两公会的规定，他是台湾公民。
Mr. Hong is a ROC citizen. Of course, he can come back to his home country. We welcome him.
Thank you. I think what I get now is that from you is that A, that it was not registered, B, that the court said that they were not indulging in any fraudulent activity, but they had to pay tax on whatever activity they were carrying out. 4, that he is abroad on his own violation, that it's not the government of Taiwan who is stopping him from coming back. Am I correct in understanding that? Thank you.
Correct.
Thank you. I'll also be very brief because I know that we have to finish. Do you have any laws against conversion? If you convert your religion, is that allowed in Taiwan? Number 1. Number 2, do you have any restrictions on interfaith marriages?
There are no legal restrictions whatsoever. Usually, such restrictions are imposed upon the religious on the followers by religious leaders. So we are not involved in this area at all.
Article 20, I just need, sorry, you.
Sorry, can I still one question on freedom of religion? It relates to paragraph 257 of the original report, that is alternative military service, conscientious objection, where it says the President granted special pardon to 19 prisoners of conscience who refused to serve in the military for religious reason in the same year. Is that still 1999? I don't know what the same year means. And secondly, now, as I said, as of 2011, 426 draftees carried out alternative military service for religious reason. How is that presently? Because I think the system was changed. Yeah, could you please explain? And also, people had to prove that they were resisting to be drafted for religious reasons. How could they prove it? Was there a special commission that looked into whether their concerns were genuine? What is if somebody is a pacifist? That is not a religion. Could a pacifist not refuse to serve in the army? Were those the people who were then sentenced and were becoming prisoners of conscience? Please explain.
我首先说明。
In Taiwan, all adult men have the obligation to serve in the military as stipulated by the Constitution. However, before 1999, some of these men, based on religious ground, claimed that their belief supported personal freedom, and they refused to serve in the military. As a result, they faced criminal charges. Later, our president gave pardon to 19 of these people,